Tēnā! Nice to be back with you all. Taught students, I do enjoy taught students, and I'm excited to be back for a couple of weeks. So what are we going to be doing? Well, in the distant recesses of your mind, you might remember that we stopped in the middle of a topic discussing causation in fact, and I said I'd be back to finish that and to do the topic of remoteness, and that's what we're going to be doing today. My apologies for a late posting of your reading yesterday. I sort of jet lag. I just hadn't gotten round to putting it up and thinking about it. So I'm sorry for that. And then tomorrow we're going to be starting on a particular issue in negligence liability, and that is where the plaintiff has suffered mental injury unaccompanied by any physical injury to their body. And there's a selection of case law that we'll be looking at, very interesting case law. And this area is relevant because it's still an area which is open for claims for compensatory damages in New Zealand, despite the damage being a form of personal injury and despite Section 317 of the Accident Compensation Act. Okay, so back to causation in fact. So let me recap. We draw a distinction between divisible and indivisible injury. Divisible injury is where, say, two different defendants negligently inflict injury on the plaintiff, but it's possible to divide up their contribution and identify each separate injury and ascribe it to a particular defendant. And in that case, each defendant is only responsible for the injury that they have inflicted. Indivisible injury is where that is not possible. The injury cannot be divided up according to a defendant's responsibility. We learned that the traditional test for causation in fact is the but-for test. And some cases, for example, Wilshire that we looked at, and also a case we haven't looked at, a short case which is referred to in Ambrose called Atkinson. So that's the New Zealand equivalent to Wilshire. Those cases have insisted on strict application of the but-for test and have scotched the idea of proof of causation by other means. For example, in Wilshire, the House of Lords said the McGee principle of proof of causation by proving a material increase in the risk of injury was not a general test of causation. And if the plaintiff couldn't prove but-for causation, then the plaintiff failed. But there have been different approaches by courts in attempts to relieve what can often be an insuperable barrier for the plaintiff in proving but-for causation. And I think we looked at the sort of cases where it can be hard for plaintiffs to prove causation. In medical cases where it's hard to distinguish between the underlying condition that the plaintiff is suffering from and the contribution made by the defendant's negligence, say a failure to come up with a timely diagnosis or proper treatment. Current limits of medical science may only establish a material increase in risk or a correlation. For example, the link between smoking and lung cancer, for a long time, the medical science could only prove a correlation, and that if you smoked for long periods of time, it increased the risk of lung cancer. Now we have that proof, but in many areas we still, we lack, because of the limits of medical science, the ability to prove that. Wilshire is a case illustrating the third bullet point, where there's more than one causal agent at work. And so, as I said, courts have often insisted on proof, strict proof according to but-for, but sometimes courts have tried to come up with approaches to make it easier for plaintiffs to prove causation. And they do this because causation happens after a finding of negligence or breach of duty. So sometimes the plaintiff's inability to prove causation can seem like a technical barrier to a wrongdoing, to finding liability on behalf of a wrongdoing defendant. So there's a temptation to try to sweep it away. We saw arguments to reverse the legal burden of proof, which courts have turned their face against, have said, no, that's not a way. But what I'm going to talk about in the balance of this hour is the mechanisms used by courts to try to lower the barrier in proving causation for plaintiffs. And that's where the Ambrose case comes in. A decision in 2008 of the New Zealand Court of Appeal. Now, this is a decision under the Accident Compensation Act, causation, whether there is personal injury caused by, whether the plaintiff's personal injury was caused by medical misadventure. I'll explain that in a minute. So some might try to say that this case is distinguishable because it's an ACC case and not applicable at common law. But Justice Glazebrook goes to considerable lengths to discuss common law cases. So I would suggest that this is an important decision on causation in negligence in tort law. So in this case, the question was whether the causative link between the claimant's personal injury, here her death, and a head of cover at that time, medical misadventure, was established. Now the relevant head of cover is treatment injury, which only requires proof that treatment or failure to give treatment caused personal injury to the claimant. At that time, medical misadventure was the relevant head of cover, and it could be proved in two ways. One was proof of what was called medical error, and it was defined essentially as common law negligence. So negligence on behalf of the health professional. And in this case, the physician, Dr. Hart, had failed to diagnose a rare heart condition that Mrs. Ambrose suffered from, as a result of which she died. And the difficulty in establishing causation was her death caused by that delay in treatment, in diagnosis and treatment, or by her underlying condition, or a bit of both. So she had just delivered a baby. So this is a woman in her 30s, just delivered a baby, discharged home, suffered serious chest pains, readmitted to hospital, where she stayed for about a week, where they were running tests on her, a week and a half, and then she suffered a catastrophic heart attack, and it was caused not by the usual cause of heart attacks, and that is, the sort of gunk, the plaque on the inside of arteries, which narrow the arteries and push the blood pressure up. this was caused by a dissection of her coronary artery, a major artery in the body. Basically what happened, it developed a weakness in the wall, sort of a bluish bruise, then gradually a hole developed into a tear, T-E-A-R, and then a rupture, a big hole, and the blood spurts out instead of going to the person's heart. And it's hard to diagnose, and it's very often fatal. So she suffered a catastrophic heart attack caused by the dissection of this artery. And it's a complication of childbirth. So the causation issue was whether so her husband laid an ACC claim, and the issue was whether the defendant physicians established negligence. Negligence was admitted. The delay in diagnosing and treating her and not booking her for an urgent angiogram caused her death. The High Court below had found that causation was established. And basically it had said that policy reasons justified a relaxation of the ordinary causation principles for the purposes of ACC cover. And they said once temporal proximity was proved, in other words, proximity in time between the negligence and the personal injury, the death, then essentially they said unless the defendant proved either that death was inevitable or there was a supervening cause, then causation would be established. The Court of Appeal in Ambrose holds that rather new test for causation was incorrect. It was inconsistent with the then leading case on causation, Atkinson, that I referred to a minute ago, which held that it was for the claimant or the plaintiff to prove causation on the balance of probabilities. There couldn't be a reversal in the burden of proof. And the Ambrose Court considered whether it should depart from Atkinson, because it was only a very short decision, but held ultimately that it was correctly decided, it was consistent with Wilshire. But then Justice Glazebrook goes through common law developments, mainly in Britain, and she's motivated to do so by the appearance of injustice to plaintiffs, which has sometimes persuaded courts to adopt modifications of the but-for approach to make it easier for plaintiffs to prove causation. And she discusses these different approaches or routes in the Ambrose case. And on this slide, those different approaches are set out. And I'm going to discuss each one of them. We've looked at material contribution to the damage or injury. That's the Bonington principle, remember. And for a while it was unclear whether that was an exceptional approach confined to cases of industrial diseases. But last time, and you won't remember this, but when you go back through your notes you will in the slides, we saw that material contribution to injury is fast becoming a broadly accepted test, a broadly adopted test. And the sorts of efforts to confine it have largely been swept away. So that's one approach which lowers the bar for plaintiffs. Material increase in risk we discussed last time too. That is essentially the McGee principle. Remember the dermatitis case where Lord Wilberforce said that if the plaintiff proves that the defendant's negligence has materially increased the risk of harm, then the burden of proof switches to the defendant to disprove the causative link. And Lord Wilberforce's approach of reversing the burden of proof was widely criticised in Wiltshire, in which Lord Bridge said, no way is material increase in risk a general principle of establishing causation. And so material increase in risk is exceptional, applied in exceptional circumstances. And one of those exceptional circumstances is the Fairchild decision in 2002, a decision of the House of Lords. So this was a mesothelioma case. The claimant, you know that in Britain plaintiffs are called claimants, in New Zealand they're called plaintiffs. I tend to call them plaintiffs in Britain because I don't want to confuse you. And I thought to myself, have I ever told you that? So they're claimants in Britain. The claimant contracted mesothelioma by exposure to asbestos during his working life. So C, the complainant. But he'd had several employers, all of whom negligently exposed him to asbestos. And his problem was, of course, that he couldn't establish which period of his employment he contracted the disease. Mesothelioma can be set off by inhalation of a single asbestos fibre, which starts the disease process. The greater the period of exposure, the more likely it is that you will contract the disease. So you can prove a material increase in the risk with greater exposure. But his problem was he couldn't prove whether it was employer A, B, or C that he had contracted the disease when working for whichever one. I hope that makes sense. That sentence is a bit mucked up. It was, as I say, it was accepted that the risk increases with the proportion of asbestos dust that's inhaled. Had there been only one tortfeasor and he had worked for that tortfeasor through the entire time, he would have been entitled to recover. But because there were more than one, if the generally accepted but-for test was applied, he could not prove causation. In Fairchild, their lordships recognised that the increase in risk principle from McGee could be developed and applied in this situation. Rather than the normal but-for test. So Lord Bingham said, "It seems to me just and in accordance with common sense to treat the conduct of A and B in exposing C to a risk to which he should not have been exposed as making a material contribution to the contracting by C of a condition against which it was the duty of A and B to protect him." So the House of Lords essentially said, on these facts, we will equate a material increase in risk with a material contribution to injury and hold that causation is established. So it's accepted that in industrial exposure cases like Fairchild, exceptionally, proof of causation can be by a material increase in risk. Loss of a chance. Okay, so the paradigm example is a failure to diagnose cancer, for example. You go in to your general practitioner with a lump in your breast. The GP palpates the lump and considers that it is benign and not malignant. And you go away reassured. But the lump continues to grow in size and you're still worried. A couple of years later, you go back and maybe you go to another general practitioner who says, I think there is a chance this could be sinister. You are referred and ultimately the lump is diagnosed as malignant. If the lump had been diagnosed properly at the outset, you might have had perhaps an 80% chance of a full cure after treatment. But after 2 years with an enlarged lump, you might only have a prognosis of, say, 40%, right? So that lost chance is something of value to people, right? You'd rather have an 80% rather than a 40% prognosis. So it's something of real value. But because you've only got a 40% prognosis, it's difficult to prove but-for causation. And so some plaintiffs and their lawyers have reformulated the claim as one where they're suing for the lost chance of achieving a cure. They're suing for the difference between 40% and 80%, saying that I have lost a 40% chance of achieving a cure because of the delay in treatment. And so they're reformulating the damage by saying the damage, instead of suing for a particular outcome, a cure, you're suing for the lost chance. And if you succeed, damages are discounted to value that chance, right? The 40% loss of a chance of being cured of cancer. And this is one way plaintiffs and their lawyers have attempted to get around difficulties in suing for difficulties in proving causation. So the approach has been deemed to be acceptable in some commercial cases. And I've put 3 of them on the board there, on the slide. Kitchen, so that was a negligent failure of a solicitor to issue a writ before the expiry of the limitation period. So litigation is never a guarantee of success. So the plaintiffs were suing for their chances of a successful outcome in the litigation if the writ had been issued in time. And they succeeded, and the court valued economically what the chances of success were and awarded damages accordingly. There are 2 other cases, Allied Maples and a New Zealand case, Benton against Miller Polgrain. This was a solicitor's failure to give relationship property advice to the husband with reasonable care and skill. And the husband sued the solicitor, saying, if I'd been given proper advice, I wouldn't have been taken to the cleaners to the extent that I have been by my ex-wife. But if proper advice had been given, the uncertainty is whether the wife, who is obliged to have, by the statute, independent advice, whether she would have signed the contracting out agreement, the relationship property agreement. So the court assessed the chance that she would have signed an agreement after careful advice had been given to the husband, and awarded damages on the basis of his lost chance of achieving a better outcome in his relationship property division. So he didn't get the whole lot. He got he got damages discounted to reflect his lost chance. So there's no difficulty in some economic loss cases, commercial cases, in suing for a lost chance. The difficulty has been in personal injury cases where loss of a chance analysis has been rejected across the common law. In Gregg and Scott, basically facts very similar to that hypothetical delayed diagnosis of cancer scenario that I talked about. The House of Lords said you cannot sue for loss of a chance in personal injury cases. Similarly in Canada and in Australia. And the distinction between personal injury and economic loss, you can sue for a lost chance in the latter, is that distinction has essentially been drawn for policy reasons rather than for reasons of principle. The courts are concerned about the floodgates and indeterminate liability if plaintiffs could sue for lost chances in personal injury cases. The implications for insurance, the consequences in particular in Britain for the failing National Health Service. What would be the increased damages burden on the NHS if loss of a chance could be sued for. Obviously, in New Zealand, because of the ACC scheme, we don't have that spectre of floodgates in personal injury cases. But query whether this distinction is unjust to plaintiffs. I think most people would value their health above their economic interests. And it's certainly not one based on principle, it's based on policy, isn't it? The next approach, and it's one which the New Zealand court in Ambrose said, gave it a tick, and said, we like this one is for us. And that is drawing an inference of causation based on some evidence of a causal link. Now, in the Wilshire case, Lord Bridge had described McGee as a simple case of drawing an inference of causation, rather than as authority for a general principle of material increase in risk. And so springboarding off that analysis, courts, particularly in Canada, but now also in the Ambrose case, have said that once the plaintiff has established breach of duty, an injury occurring perhaps in close proximity to the breach, the court may, stress may, not must, draw an inference of the existence of the causal link between the breach and the injury adverse to the defendant, in the absence of evidence to the contrary. And even though proof of causation doesn't reach the balance of probabilities. The Court of Appeal has said that very little affirmative evidence on the part of the plaintiff may justify drawing an inference of causation. And then the evidential, once some evidence of causation has been adduced, and that might only be a close temporal proximity between the breach and the injury, the evidential, not the legal burden, the evidential burden of persuading the court to decide the issue in his or her favour shifts to the defendant. to point to evidence suggesting no causal connection exists. And so, here are some of the quotes. So, Justice Sapinka referred to there's Justice Glazebrook in the Supreme Court. Justice Sapinka, there's a case called Snell, something rather in Snell, I forget, is the Canadian case that the Court of Appeal in Ambrose adopts as exemplifying this approach of drawing an inference of causation. And so there's paragraph 61 from the decision. So the legal or ultimate burden remains with the plaintiff, but in the absence of evidence to the contrary adduced by the defendant, an inference of causation may be drawn. While Atkinson is clear that in New Zealand the legal burden to prove causation remains with the claimant and does not shift to the corporation, the case does not rule out a shift of the evidential burden passing to the corporation. The Canadian Supreme Court approach is for a tactical burden to pass to the defendant when some evidence of causation has been adduced to the plaintiff. We endorse the Supreme Court of Canada's approach. So the court is indicating there that of all these various approaches for making it easier for plaintiffs to establish causation, this is the one the court most favours and endorses as applicable in New Zealand. So it would enable the court to look at the evidence as a whole and to draw an inference of causation in cases of causal uncertainty, when the evidence supports only a possible connection between the breach and the injury. The only time the court says that inference cannot be drawn is if medical science is prepared to say there is no possible causal connection. And the court is not bound by the evidence of the experts. The court can depart from the expert view that there is insufficient evidence of causation, base itself on a possible causal connection, and draw an inference. I've referred to temporal proximity. The court says that where there's a close temporal proximity in time between the breach and the injury, that can be some evidence of a possible causal connection upon which it can draw the inference. Another way the court discusses is statistical evidence showing a correlation between the breach and injury. So if there is statistical evidence showing that late diagnosis increases the risk of developing, shows a poorer prognosis, that statistical evidence, which only refers to the generality of cases and not to this plaintiff's particular case, but it can be the basis, it can be some evidence justifying the court drawing an inference that the causal connection exists. Okay. Some have argued that inferential reasoning isn't a new principle of law, but just involves the application of common sense. And that point was made in Drake against Harbour. Not a principle of law, nor does it involve an alteration in the burden of proof. Rather, it's a matter of applying common sense. So I think that's one reason why the Court of Appeal was particularly attracted to it. It does little violence to established principles of law. Okay, so some takeaways. The distinction between divisible and indivisible injuries is important in this area. There's a definition of divisible injuries. If it's possible and practicable to divide up the defendant's respective contributions, then each defendant is liable only for that part of the damage they have in fact caused. We've learned about the traditional but-for test for causation. We've seen that the alternative principle of proving causation by proving a material increase in the risk. There's a mistake there. The third bullet point, the circumstances in which material contribution to injury, not risk. So put a line through that. Material contribution to injury, that's the Bonington principle, is the circumstances when that's been applied are expanding and it's fast becoming a general principle of causation. So various judicial approaches to proving causation, material contribution to the risk of injury, exceptional, Fairchild is an example, proof of loss of a chance, possible in economic loss cases. Generally the weight of authority is against it in personal injury cases, much less relevant in New Zealand. Inferential reasoning, some people regard this as just a common sense approach, that is of inferring a causal link in the presence of some evidence of a causal link, has been given the tick by the New Zealand Court of Appeal in the Ambrose case and has been quite widely applied since. Okay, so that's causation in fact, and we're now going to move on to remoteness. Now just give me a moment or two and I'll get my slides up, talk among yourselves for a bit. Okie doke. So, remoteness. You might have a bit of an idea of what this is about, and as I was going through the cases and boning up on the area yesterday, I thought to myself, it hardly ever succeeds, or it doesn't seem to succeed very often. Why do I spend time doing it? But I guess I want you to have a complete idea of the elements of a cause of action in negligence. So we're now going to consider the rules of remoteness of damage. So as we've seen, causation in fact is the prerequisite inquiry. And once that exists, the question then becomes how far legal responsibility for the damage in fact caused by the defendant's negligence ought to be attributed to the defendant. Ought, that suggests that there is a fair bit of judicial discretion involved. It's not an objective factual matter. It involves evaluation. It's a normative inquiry, an ought inquiry rather than an is inquiry. And the problem is that a simple act of negligence can have all sorts of unexpected and far-reaching consequences. There are torts, and the tort of deceit, which we won't be studying in this course, is an example, where it's considered justifiable to impose liability for all of the damage flowing from the defendant's wrongdoing, whether foreseeable or not. And I think in the tort of battery, Nikki will have discussed Bettel and Yim with you. I think we did this earlier. That's a case where the defendant batterer will be liable for all the injury inflicted on the plaintiff, whether foreseeable or not. But in negligence and many other torts, it's considered unjust to make the defendant answerable for events too far removed from the original breach of duty. So, the object of the remoteness inquiry is to ascertain whether the link between the defendant's conduct and the ensuing damage is sufficiently close or proximate so that it's fair and reasonable that the defendant ought to be liable and pay for it. So there's lots of evaluative words in that sentence, like sufficiently close, right? Which allow wiggle room. Fair and reasonable as a matter of policy that the defendant should pay. So it's all about judgment. Okay, so the first case is Wagon Mound number 1. We've done Wagon Mound number 2, which is an important authority in the area of breach of duty. Remember, is it a real risk? And then the court goes on to talk about the negligence calculus. Doesn't use those words, but those are the factors that the court weighs and that a reasonable person apparently weighs before deciding how to act. This case is an important principle on remoteness, the Wagon Mound number 1. And this is the uncomfortable situation where you've got two sets of litigation from the same events with different outcomes. It's like the O.J. Simpson case, where O.J. Simpson was found not guilty in the criminal case of murdering his wife, but then there was a wrongful death case brought by the family where liability was established. One factor there, of course, is a difference in the standard of proof between beyond a reasonable doubt and balance of probabilities, right? But these are two civil cases. And I think I told you before that the explanation is that the findings of fact are different in each case. So remember the facts. The Wagon Mound is anchored in Sydney Harbour. The engineer on the Wagon Mound negligently discharges a large amount of bunker oil into Sydney Harbour, where it floats some 200 to 300 yards on the surface of the water and comes to the plaintiff's wharf, where welding was underway. The work was initially stopped because of concerns about whether it was safe to carry on welding, but the plaintiff's manager was told by someone at another wharf that there was no risk of fire, and they then resumed welding. And what they think happened is that a piece of molten metal from the welding fell onto some cotton waste or a rag which was being supported on the oil on the surface of the water and ignited it. And this in turn ignited the oil and caused a huge conflagration which damaged the plaintiff's wharf. And the plaintiff is suing. In the first case, they're different plaintiffs. It's the owners of the vessels moored at the wharf who were suing in the Wagon number 2 case. This is Wagon number 1, where the owner of the wharf is suing for damage. Now, in Wagon number 2, the first case we looked at, the Lord Reid kind of massaged the facts and said, and the case was decided on the basis that it was reasonably foreseeable that oil could catch alight when carried on the surface of water in these circumstances, but that it was very rare. Not that it could never happen, but that it would seldom happen. So that was the factual basis on which Wagon number 2 was decided. So you remember, if it's if it's a real risk, if it's reasonably foreseeable, then you go on to assess the magnitude of the risk, the seriousness of the consequences, blah-de-blah. This case, the trial judge decided, and the Privy Council did not disturb the finding that it was not reasonably foreseeable that oil would catch alight when carried on the surface of water, and so that the fire was not reasonably foreseeable. So you've got two different factual findings which explain the different outcomes of the case. So do you get that? Is that clear? So this case, which is an important authority on remoteness, is decided on the basis that it was not reasonably foreseeable that oil could catch alight in these circumstances. Now, the law prior to Wagon number 1 was established in a Court of Appeal decision called Re Polemus. It's that top bullet point. That was a case in which the defendant's employee was involved in unloading cargo from a ship. A plank of wood fell into the hold of the ship as a result of that employee's negligence. There was a spark and a fire broke out, which eventually destroyed the whole ship. And the arbitrator, the case went to arbitration, found that some damage to the ship by the falling of a plank was reasonably foreseeable, but destruction of the whole ship by fire was not foreseeable, not reasonably foreseeable. The English Court of Appeal held that once it is found that the defendant is in breach of duty, small n negligent, he's responsible for all the consequences of his negligence, whether reasonably foreseeable or not. So the rule of remoteness applied was that very broad remoteness rule we see applied in the intentional torts, trespass to the person. Foreseeability was irrelevant to damage once breach of duty is found. It added the qualification that the damage had to be a direct result of the negligent act in some way, a direct result. So the test of remoteness of damage included some concept of directness, but there was a lot of vagueness around what that meant, which made the test difficult to apply. Time for a break, people. We'll take up there at 5 past, and I'll tell you about what the Privy Council held in the remoteness, in the Wagon Mound case.
So if the employee had like this SAE service, so that space was private, so they can sue anyone.
Yes, and there are subsequent cases. So each one of them would be liable for the full amount. But then there are subsequent cases which talk about how, as between the employers, they can work out a division between them.
But
that's not the plaintiff's worry. The plaintiff can sue any one of them.
He just gets
or all of them. Yeah. Okay? Right.
Excuse me, sorry. I sent you an email a couple of days ago.
All right.
And we wanted to do like if we had time like in before lecture or like whenever we just wanted to like advertise for this event we're doing for like a law club.
Okay. How long will it take?
Yeah.
Oh.
Yeah.
You can do it right before we start in the second hour? How does that work?
Yeah.
Okay. Do you need to use this? Do you know how to use it?
We can just use it. Yeah, we can just put it on here.
Oh, okay, cool.
Because it's like this.
pop it under and see if it works. Yeah, good. Good. Okay.
We'll do it before the.
Fine.
Yeah.
All right.
Thank you.
Good. Come up at 3 minutes past. Oh, just put.
That's fine. Is it good? Yeah, I think that's.
Do you want to?
Yeah, that's good. Can I speak now?
Yeah, go for it.
Kia ora everyone. I'm a volunteer for the Alliance team in the Equal Justice Project, and we're hosting an event with the Aotearoa Legal Workers Union about the reality of a life as a junior lawyer. This will be a session dedicated to understanding your rights as a legal professional and what you can do to help the legal profession a better environment to work in and provide you with the vital knowledge you need to make your entry into the workforce an enjoyable and equitable experience.
And this is going to take place on Monday, the 29th of September from 6 p.m. to 7:30 p.m. at law school on the Short Street, building 801, room 225. So you can also go to the EJP Instagram bio to register and if you want to know more about this event. Thank you.
Look at that, even got a clap. Okay. So where were we? I told you about re Polimus, which was the current law before the Wagon Mound number 1 case. And it was responsible for a strict remoteness approach, all consequences provided they were in some way directly connected to the breach of duty. So the Privy Council considered that this was an unreasonable burden on defendants and favoured a test of reasonable foreseeability. What am I doing? Instead of the Polimus test. The court said, if some limitation must be imposed upon the consequences for which the negligent actor is to be held responsible, and all are agreed that some limitation there must be, why should that test, reasonable foreseeability, be rejected? I should show you where this comes from so that you can make a note of it. It's on page 423 in the middle there. Be rejected, which, since he is judged by what the reasonable man ought to foresee, corresponds with the common conscience of mankind, and attest the direct consequence, the Polimus test, be substituted, which leads nowhere but the never-ending and insoluble problems of causation. So, reasonable foreseeability test of remoteness was favoured over the Polimus test, essentially for policy reasons. The court talked of current ideas of justice or morality. They considered re Polimus too harsh a rule. It wasn't fair to defendants that they should be held liable for all consequences of their negligence, no matter how grave those consequences and unforeseeable, and how trivial the act of negligence might be. So they should only be liable for that which they ought to have foreseen. And so they hold that the Polimus case was wrongly decided and they overrule it. So they're focusing instead on culpability and fault, corrective justice, prioritising it over the plaintiff's interest in compensation, right? So this is another case where two of the functions of tort law are in tension, and the court prioritises one over the other. But the reasonable foreseeability test in Wagon Mound, established as the test for remoteness, came thereafter to be quite heavily qualified. So no sooner is it established than the court takes away a bit with the other hand. So starting first with Hughes and Lord Advocate, a Scottish case, very complicated facts. There's my attempt at showing what the location might have looked at. So this is a Scottish case. Some post office employees were repairing cables under the street, and they opened a manhole in the surface of the road, which was 9 feet deep and they put a weather tent over the manhole. And then they covered that with a tarpaulin for better protection. But they left a gap between the edge of the tarpaulin and the roadway of a couple of feet in one of the corners. It started to get dark at 3:30 p.m. Did I say this was Scotland? And so then they fixed 4 red paraffin lamps to each corner of the tent. Then they leave the site at about 5 p.m. for a tea break at a nearby post office building. Before they leave, they took out the ladder that they had used to get down into the manhole, and they left it on the ground outside the tent. You're following me so far? Later that evening, the plaintiff, an 8-year-old boy, and wait for it, his 10-year-old uncle, this is Scotland, were walking down the road. And of course, they started meddling with the equipment. This was a great discovery, wasn't it? They took the ladder from outside the site and one of the paraffin lamps, and they went into the tent. And they went down inside the manhole to explore. After exploring the manhole, they came out of the manhole safely. So far, so good. Somehow, the plaintiff, the 8-year-old, tripped over the lamp, and it fell back into the manhole under the tent, through the gap in the tent, between the tent and the roadway. And there was a huge explosion with flames that reached up to 30 feet in the air. And the plaintiff fell into the hole due to the impact and suffered severe burning injuries, for which he sued. Now, it was unclear how the explosion had occurred. The trial judge found that the most likely explanation was this. Now, try to follow me. It was the result of the lamp being knocked over by the boy into the gap not covered by the tent. The lamp breaks. Paraffin from the tank of the lamp leaked out and vaporized. And the lit wick of the lamp ignited the paraffin vapor and caused the explosion. That's what they thought happened, right? A pretty weird and arcane set of circumstances. So it was clear that the post office employees were in breach of duty. Their breach of duty was that they ought to have foreseen that children would be attracted to the shelter and the manhole, lit up as it was with red paraffin lamps, with the ladder outside, that this would prove an allurement to children, and that it could be a source of danger to them. They could well interfere with it and hurt themselves. So they had a duty to protect these children from entering the shelter and going down the manhole. So that was the breach of duty. So the question was one of remoteness. Whether the huge explosion which had occurred in the way postulated by the trial judge was reasonably foreseeable or not. The lower courts had dismissed the plaintiff's claim on the ground that this highly unusual combination of circumstances of paraffin escaping from the tank of the lamp, vaporizing and being lit by the wick, was not reasonably foreseeable. This is the case where the word concatenation enters the legal vocabulary, and it's repeated in Stevenson and Waite-Tileman, and you might wonder what it is. They talk about an unusual concatenation of circumstances. Just means combination of circumstances. But easy to impress people if you talk about a concatenation of circumstances. So the House of Lords said the following could be foreseen, was reasonably foreseeable. That the whole setup of the tent, the red paraffin lamps, the open manhole was an allurement to children, an attraction to children, and a potential danger. It was foreseeable that a boy might play with the lamp, that it might tip over and be broken, and that liquid paraffin might spill out and be ignited by the flame, and he could be burned in that way. So burning injuries occurring in that way of liquid paraffin spilling out of the lamp and being ignited were reasonably foreseeable, but what it was held actually occurred, this vaporization of the paraffin and being lit by the wick, wasn't reasonably foreseeable. Now, when I describe this, I think this is all like a crazy wonderland. How do they know it wasn't liquid paraffin that spilled out and happened in the reasonably foreseeable way? But don't fight with the facts. Just take it that the trial judge had found the most likely explanation was that the paraffin vaporized and was lit by the wick. Okay, so burning injuries by liquid paraffin catching alight, if the children entered the shelter, were reasonably foreseeable, but the explosion occurring in this highly unusual way was not, the courts below had said. Lord Guest in the House of Lords reverses the courts below and holds that the injuries to the boy were not too remote. And this occurs because the reasonable foreseeability test is qualified in this case. It's not abandoned by any means, but it is kind of massaged. Lord Guest didn't consider that the reasonable foreseeability test requires that all the details of what happened leading up to the injury should be reasonably foreseeable. So that's the first takeaway from this case. It's not necessary for a defendant to foresee the precise concatenation or combination of circumstances leading up to the accident or the injury. Once the damage itself has been deemed by the courts to be of a reasonably foreseeable kind, the exact way in which it occurred doesn't have to be foreseen for the defendant to be held liable. Okay, so that's that second bullet point on the slide. The court said, I wonder if I've got a slide of this. No. The court said, and this is at page 855 at the bottom is the relevant. In order to establish a coherent chain of causation, it is not necessary that the precise details leading up to the accident should have been reasonably foreseeable. It is sufficient if the accident which occurred is of a type which should have been foreseeable by a reasonably careful person. Okay? So that's the first point. Second point. The judges below considered that the explosion wasn't reasonably foreseeable. As to this, Lord Guest held that it was enough if the injury by burning was of a type or kind of damage which was reasonably foreseeable. So the reasonable foreseeability test kind of morphs into a requirement that the type or kind of damage which occurred be reasonably foreseeable. He defined burning by explosion, the explosion which occurred in the way it occurred through vaporized paraffin being lit by the wick, and burning by liquid paraffin igniting as two different injuries of the same kind or type, both injuries by burning. So, this is the principle. So long as the damage suffered is of a kind or type or class that's reasonably foreseeable, as a result of the defendant's negligence, it's immaterial that an injury of a subtype, if you like, which occurs in a different way, is not. It's enough that the defendants could reasonably have foreseen injury by burning. And the fact that the burning injury was inflicted by way of an unforeseeable explosion was immaterial. So that's that third bullet point there. It's sufficient if the initial accident or injury is of a type or kind which is reasonably foreseeable. Unpredictable details going to the extent or the severity of the damage, if they are of the same kind, are treated as going to the extent of damage. And they're not too remote so long as they're causally connected to the breach of duty. So it's all a bit difficult to understand, but we are seeing here the kind of massaging of the reasonable foreseeability test of remoteness in a pro-plaintive way, in sympathetic personal injury facts, right? They're qualified by adding this idea of the type or kind of injury only having to be reasonably foreseeable, not all of the consequences having to be reasonably foreseeable. And also the manner in which the accident occurred, if it occurs by way of an unusual combination of circumstances. Nobody could really expect defendants to be able to gaze into the crystal ball to foresee those circumstances leading up to an accident or an injury of a foreseeable kind. So, Lord Guest says, an explosion, this is here, is only one way in which burning can be caused. Burning can also be caused by the contact between liquid paraffin and a naked flame. In the one case, paraffin vapour, and in the other case, liquid paraffin is ignited by fire. I cannot see that these are two different types of accident. They are both burning accidents, and in both cases the injuries would be burning injuries. Upon this view, the explosion was an immaterial event in the chain of causation. It was simply one way in which burning might be caused by the potentially dangerous paraffin lamp. Okay, so let's see Bradford against Robinson. I'll give you this as a typical illustration of application of the principle. So the defendants carelessly exposed their employee van driver to extreme cold in the course of his duties. In consequence, he suffered frostbite. The court held that the defendant's negligence in exposing the plaintiff to severe cold was likely to cause a common cold or pneumonia or chilblains. But since frostbite was the same type or kind of injury as these other forms of harm, the defendants could be held liable for it. So have a look at that case if you're struggling sort of with what the principle is. So all this was the qualification added by Hughes was accepted by the New Zealand Court of Appeal in a case called Stevenson and Waite-Tileman. Judgment of the President, Justice Richmond, later the President. In that case, the appellant was employed by the respondent as a steeplejack, and a wire rope on a crane was in very poor condition, and while working on it, he cut his hand. As a result of it, he became ill. His condition deteriorated so much that by the time of trial, his condition was described as pitiful. So the extent of his injury was clearly unforeseeable as a result of a cut on his hand with a wire rope. And the defendant argued that it was too remote, applying the Wagenman No. 1 principle of reasonable foreseeability. Okay, the key issue in the case was whether the egg-shell skull principle remained good law after the Wagenman No. 1 decision that the principle of remoteness was reasonable foreseeability. You can see how the two might be regarded as inconsistent with each other. So what is the egg-shell skull principle? Well, it was well accepted long before Wagenman No. 1 and the reasonable foreseeability principle came to be accepted as the normal test of remoteness, that a tortfeasor had to take his or her victim as they found them. Couldn't complain if the extent of harm the plaintiff suffered was increased through some pre-existing vulnerability of the plaintiffs, such as that the plaintiff suffered from a skull made of eggshell, so that if you tapped it, it completely caved in, and the defendant was responsible for all the damage caused, even if the defendant didn't know of the pre-existing vulnerability or susceptibility. So an example, for example, is Smith and Leach Bain, where the plaintiff had a pre-existing tendency to malignancy in his tissues. These are all cases before medical science could explain these phenomena. He had a burn on his lips caused by the employer's negligence. That was reasonably foreseeable, but it progressed to cancer, developing at the site of the burn, which was not foreseeable, but due to the eggshell skull principle, the defendant was liable for the full amount of the damage. So that's the eggshell skull principle. You can't complain of unpredictable consequences due to the pre-existing vulnerability or susceptibility of the plaintiff. So the question was, so Stephen Todd calls this the existing state rule, that a tortfeasor is obliged to take their victim in the existing physical, psychological and financial state they were in at the time of the tort, and cannot complain that the damage is worse than could be anticipated by reason of that state. Of course, if the defendant could not foresee any damage at all, he or she won't be liable. But provided some bodily injury was reasonably foreseeable, it's no answer that a, quote, normal person wouldn't have suffered injury to the same extent. After the Wagon number 1, which adopted this principle of remoteness of reasonable foreseeability, naturally the question arose as to whether the eggshell skull principle still survived. Was it still good law? What was the effect of Wagon number 1 on that principle in personal injury cases? And that's what Justice Richmond is considering in Stevenson and Waite-Tileman. He clarifies that the Wagon number 1 rule is that only damage or injury of a kind which is reasonably foreseeable is legally recoverable. The defendant is not liable for damage of a kind or type which is not foreseeable. But, adopting the Hughes case, the defendant doesn't have to foresee all the details leading up to how the damage occurs, nor does the defendant have to foresee unpredictable and unforeseeable consequences going to the extent of damage of the same kind. So that is how they square the circle. That is how the Wagon number 1 principle of reasonable foreseeability, by now heavily qualified by Hughes and Stevenson and Waite-Tileman, is reconciled with the eggshell skull principle. So by this time, what the Privy Council actually decided in Wagon number 1 differs from how the rule has been developed in subsequent cases. Now, there's a great summary in Stevenson and Waite-Tileman on page 160 at the top of all this. It is now quite clear that the rule of foreseeability of damage is concerned only with foreseeability of a real risk of injury of a kind or class or character which embraces the actual damage in suit. Although the broad basis of the rule is that it would be unjust to hold a wrongdoer liable for damages of a kind which he could not reasonably foresee, nevertheless, the rule accepts the position that there are many matters of detail which nobody could predict of the foreseeable kind, or they may consist of unpredictable details going to the extent or severity of damage. To this extent, then, the general language used in the judgment in the Wagon Mound number 1 case is clearly to be read with some qualification. So, he goes on to hold that the eggshell skull principle survives the Wagon Mound number 1 and remains unaltered. It's part of New Zealand law. He recognised that there were problems reconciling the eggshell skull principle with the Wagon Mound number 1 principle of reasonable foreseeability as originally formulated, but once it was qualified by later cases, in particular Hughes, it becomes reconcilable. Thus, all that has to be reasonably foreseeable is the kind of injury or damage which occurred. Don't need to foresee its full amount or extent. Unforeseeable consequences of that kind are seen as merely going to the extent of injury. And you then just have to demonstrate that those consequences were caused by the initial injury. So, he says on page 405, I think it is, there. The decisions in England, Scotland, Ireland and Canada are of importance because in all of them the courts have limited the test of foreseeability to the initial kind of injury. The consequences, often unforeseeable, of the initial injury have been treated as falling within the field of the extent of injury. So all this adds a very pro-plaintive gloss or qualification to the Wagon Mound number 1 principle of reasonable foreseeability. But all this demands, so I've put the quotes up, I think, that courts identify different kinds or classes of injury or damage first, and then to decide whether the particular outcome that occurred on the facts is of the same kind or type of damage. So first of all, they have to identify different kinds or classes of damage and decide whether that particular kind of damage was reasonably foreseeable, and then whether the damage which actually occurred is of the same kind or a different kind. Does that make sense? That makes some sense? This is the arcane world that I've used that word arcane twice in this lecture. This is the crazy world that courts invent for solving disputes. On the duty of care issue, we saw that courts categorise damage broadly in terms of personal injury, and they distinguish between physical bodily injury to the plaintiff's person and psychological injury, and physical damage to property, so personal injury, property damage, and economic loss. So those are the three broad categorisations, right? When it comes to remoteness, the categorisation tends to be a bit more specific than that. For example, in Stevenson and Waite-Tileman, Justice Richmond refers to two different kinds of damage as being damage by fire and damage by pollution, referring to the Wagon Mound number 1 facts. So those are two different kinds of damage that he draws. So that first bullet point, I will discuss the cases first in order to illustrate that first bullet point on the slide. So for an example of a court narrowly defining the kind of injury which has to be reasonably foreseen, I'll refer you to Tremaine and Pike. Now, the facts were these. So, if the court defines the kind of injury which has to be reasonably foreseeable narrowly, it is easier to exclude the damage actually suffered as being too remote, right? So, the plaintiff worked as a herdsman for the defendant, and the plaintiff contracted a rare condition called Wheals disease, and that's caused by coming into contact with rat's urine. Wheals disease per se was not reasonably foreseeable. Rare. Even though other injuries or infections associated with rats were reasonably foreseeable. So the court said, for example, that a rat's bite or food poisoning caused by consuming food or water contaminated by rats, these were reasonably foreseeable injuries. But Justice Payne held that Wheals disease was, quote, entirely different in kind from a rat bite or food poisoning by the consumption of food or drink contaminated by rats. I do not accept that all illness or infection arising from an infestation of rats should be regarded as of the same kind. Right? And so the Wheals disease was too remote to be recoverable. So does that, I know it's weird stuff, but does that make sense? He defined Wheals disease as of a different type or kind of injury as other injuries caused by rats, which were reasonably foreseeable. A different judge might have said that any injury caused by an infestation of rats is reasonably foreseeable and include Wheals disease within that as merely going to the extent of injury. Do you see how so there's a huge amount of judicial discretion as to how the court defines the initial type or kind of injury which has to be reasonably foreseeable, either narrowly or broadly, so as to bring the plaintiff's injury within it or as being too remote. Okay, so contrast with a broadly defined injury in the core case. In that case, the claimant's husband suffered a head injury due to his employer's negligence. It caused him to suffer a depressive illness and eventually 6 years later to commit suicide. And the issue was whether the suicide was too remote or not. The House of Lords held that the depression that was negligently inflicted on him was reasonably foreseeable and that his suicide was the same kind of injury, so that his ultimate death was of a reasonably foreseeable type, right? So if the suicide itself was not reasonably foreseeable, that didn't matter. The initial injury of depression was, and the suicide was of the same type, right? Have a look at Jolie and Sutton, another House of Lords decision. The difference between the Court of Appeal and the House of Lords approach to remoteness illustrates this point about this definitional point. The facts were that a 14-year-old boy was injured while crawling underneath a disused boat, and the boat had been propped up and the council was negligent for leaving it there as a source of danger. The Court of Appeal held that the boy crawling under the boat and it collapsing on him was injury of an unforeseeable kind. Foreseeable kinds of injuries were injury from perhaps climbing on rotten planking in the boat, which was liable to give way. In the House of Lords, however, the foreseeable type of injury was cast much more widely as any injury occurring as a result of interfering with a disused boat, so that the actual injury caused by crawling under it was was injury of a reasonably foreseeable type. I hope it's a bit hard to it doesn't compel itself as necessarily a logical way of going about things. But what I'm talking about is the kind of judicial discretion in how the court defines the type or kind of injury which has to be reasonably foreseeable. If it's defined broadly, it's unlikely that unforeseeable consequences will be held too remote. If it's defined narrowly, then what actually occurred can more easily be held to be of a different kind of injury and too remote. For example, in Page and Smith, which is a case we'll come back to in the mental injury area, the House of Lords treats damage, injury, by physical injury to the plaintiff's body and psychiatric injury as injuries of the same kind. Not two different kinds of injury for remoteness purposes. In personal injury cases, not relevant in New Zealand because we don't litigate them, but the tendency in personal injury cases is to define the type or kind of injury broadly as, personal injury, so that you don't distinguish between physical injury and psychiatric injury, as in Page and Smith. So remoteness issues tend to arise in property damage cases and economic loss cases. And there's greater room for flexibility and argument. And the way the court defines the initial kind of injury, which has to be reasonably foreseeable, whether narrowly or broadly, can determine whether the plaintiff can succeed in recovering it, or whether it's outside the area of recovery as being too remote. So a court might distinguish, for example, between expenses incurred by a plaintiff and lost profits, for example, and say those are two different kinds of injury. I didn't ask you to read the Lagdon case, Lagdon and O'Connor, the last case in the reading. I didn't ask you to read that, but just to summarise that case, the House of Lords overturned a long-standing principle in a case called Le Bosch, Dredger Le Bosch against Edison, 1933 case. Now, in that case, it was held that if the defendant is negligent, so this was a collision at sea, as a result of which the plaintiff's vessel was unusable, and the plaintiff was short of funds, poor, impecuniosity, and had to hire another vessel at much greater cost. And the House of Lords in that case held that damages for which the defendant is liable cannot be increased by reason of the plaintiff's impecuniosity or poverty. Losses due to the plaintiff's impecuniosity are too remote and not recoverable, the House of Lords held in Lebosch. But in Lagdon and O'Connor, the court overturned the Lebosch principle as no longer good law, and the relevant section is paragraph 61 of the case. They said the Lebosch principle had been overtaken by the Wagenman No. 1 reasonable foreseeability test, and it's also inconsistent with the rules of mitigation in tort and contract. There's a principle of mitigation which goes like this. A plaintiff has a duty to act reasonably, to mitigate, to lessen its losses caused by a defendant's tort or breach of contract, and can't make a defendant liable for the greater damage of its failure to do so. Plaintiffs have got to mitigate their losses, but it's only a principle of reasonableness, reasonable mitigation, and it doesn't require the plaintiff to do what they cannot afford to do to reduce the damages payable by the defendant by reason of poverty or impecuniosity. So, as Lord Hope said in the Langdon case, the Lebosch principle could no longer be reconciled with the principle that, and he says, the correct test of remoteness today is whether the loss was reasonably foreseeable. The defendant must take his victim as he finds him. This rule applies as much to the economic state of the victim as to his or her physical and mental vulnerability. It requires the wrongdoer to bear the consequences if it was reasonably foreseeable that the injured party would have to borrow money or incur some other kind of expenditure to mitigate his damages. Okay, so quickly to run through some takeaways for you. Wagenman number 1. The test for remoteness of damage is reasonable foreseeability. But that test comes to be significantly qualified in later cases, and the next 2 bullet points state the takeaway principles from Hughes and from Stevenson and Waite-Tileman, that the unpredictable combination of events leading up to an accident or injury of a foreseeable kind is immaterial, and all that has to be reasonably foreseeable is the kind or type or character of injury or damage which occurred. The defendant doesn't have to foresee its full amount or extent. Unforeseeable consequences of that same kind are seen as merely going to the extent of injury and not too remote, provided they're causally connected. Eggshell principle survives, remains good law, applies broadly to physical, psychological and financial state of the plaintiff at the time the tort was committed. And we've talked about this judicial discretion or flexibility in the broadness or narrowness by which a court defines different kinds or classes of damage and decides whether what actually occurred is of the same type or kind of damage or whether it's of a different kind or type and thus too remote. Okay, tomorrow we're going to start on the interesting area of mental injury cases. I'll scurry back to my office and figure out what I'd like you to read for tomorrow, if you would. Okay, have a good day. Cheers. Yeah.
That's a question, or I should save it for office hours.
Go ahead.
I'm just a bit confused about the difference between reasonable foreseeability at the novel duty step.
The breach.
At breach.
It's there everywhere, isn't it?
Yeah, but
Is there a difference?
I've read.
I can't make that go away. I can't make that go away.
All the cases
I
say
try to be
something
as
different.
clear as I can.
Yeah.
At the beginning, I talked about whether duty is a question of whether the injury to the plaintiff is reasonably foreseeable.
Yes.
At the breach stage, they talk about whether the damage or risk is reasonably foreseeable, and that's almost the same.
That seems the same to me
as the
what we just
remoteness
discussed.
stage,
Yeah.
right? I'm not saying it all makes sense and that it's logically and scientifically watertight. These are rules invented by judges, and some of them are bullshit, you know? I mean, some of them are, you just got to work with what's there.
Yeah.
A lot of this is about, as potential litigators, learning the language that they talk, getting yourself inside their heads and trying to learn how they think. And yeah,
So is
I
there-
try. I'm with you. I try to make it as clear and logical as I can, but you come up against these. Everything seems to weave into everything else. Like, scope of duty,
Yeah.
that can be thought of as a duty issue or a remoteness issue.
Yeah.
And you're never sure whether a court is going to say, the problem here is a remoteness problem, or whether it's going to say it's a duty problem.
Yeah.
Because of the interrelationship of all these concepts. Yeah, I know.
Vanilla.
Look, I totally
Okay.
get it. It's frustrating, and you're right to be frustrated.
Is
It
there,
is.
So
It
is there
is.
a distinction between, because I remember we were talking about in the breach stage, just magnitude of risk. If the risk crosses the threshold of being reasonably foreseeable, how likely was it to eventuate?
Yeah.
When we're talking about crossing
Well,
the
yeah,
threshold,
yeah.
is that the same as what we
Well,
just discussed?
in some ways you are, aren't you? You're talking about
'Cause if it wasn't there,
whether
then it
the
wouldn't be here.
damage is reasonably foreseeable, which is the same question you're asking at the threshold of the breach issue. Is it a real risk? Is it reasonably foreseeable? It's the same question. Yeah.
Okay.
Yeah.
Makes as much sense.
A bit more confused, but anyway. So I'm still a bit confused how we reconcile the actual principle again. Like,
Right. So the plaintiff's head falls in because they will say that some damage, some injury was reasonably foreseeable to the plaintiff as a result of tapping them on the head like that. The extent of damage, the severity, was not reasonably foreseeable, but you can still recover for it because it's of the same kind.
okay.
Bodily injury.
Okay.
So by
get it.
applying the reasonable foreseeability test as qualified by the later cases, you can reconcile
Okay.
the wagon mound with the eggshell scalpers.
So
I
as
probably didn't explain that as clearly as I
So
could have.
as long as it's the same kind.
I just better get away from here. Wait for me.
Thanks.
Cheers.
Thanks. Yeah, they have health psych.
And on Thursday.
Oh, yeah, no, it's Tuesday. No, they don't have health psych. They've got, I don't know what they've got actually. I think some of them have just got labs. They're not usually late for this Tuesday class. Oh, it was the test last night.
Yeah, I haven't turned on though.
Yeah, they'll be in recovery.